And welcome to the EDRM Global Webinar channel. My name is Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM. Today's webinar is an EDRM collaboration with our trusted partner, eDiscovery Today, and it's called Important eDiscovery Case Law Decisions for March of 2024. Our faculty experts are Doug Austin, Tom O'Connor, and the Honorable Judge Andrew Peck. We welcome your questions and feedback in the Counsel. Questions will be answered both during and at the end of the webinar, and this webinar will be available for your replay at your convenience for the next quarter, as are all of our EDRM webinars. Kaylee Wallstad, EDRM's Chief Strategy Officer, is here. Can you please tell us what resources are available today?
Absolutely. And as always, this is one of my most cherished and favorite presentations. And Doug, are we in the fourth year now? Well into the fourth year?
Not quite, but we're getting close.
Is it? I think then it's next month.
Well, for the webinars, not till July, but we're not far off.
Okay. All right. Well, we're going to have something special for that 4 years. And welcome today. We are loving our On24 platform with so many more ways for you, our audience, to engage. Check out your console to the right of your screen. You'll see a question mark icon, and that's where you can type in your questions for today's faculty, and we highly encourage you to do so. Slides will be made available after the webinar has concluded. You'll also see a paperclip icon for related content. If you click on that, you'll see today's resources carefully curated just for you. First, there's an On24 Engagement Tools Description PDF for you to download to help you better engage with the platform. There's a link to click to subscribe to eDiscovery Today blog and never miss a thing. It's my favorite way to start the day. And I have to say, I'm a huge fan of Doug's brand of humor, which he generously sprinkles in. There's a link to learn more about the Honorable Judge Peck and how to engage with him. And then a link to order your copy of Tom O'Connor's spicy new book, eDiscovery for the Rest of Us, recently updated in a collaboration with EDRM's trusted partner, NextPoint. And be sure to save your seat for next month's Case Law Edition on April 27th. And up next on EDRM's webinar channel, next week, April 2nd, Maximizing Data Collection with SaaS Innovations. Speaker bios can be clicked and popped up to learn more about today's faculty. And there's also, you'll see the Twitter bird. You can follow EDRM and eDiscovery Today on LinkedIn. And my favorite, just like Zoom, the smiley face emoji, you can click it and there's many more reactions you can share during the webinar. And we highly encourage you to engage with them. We're having a lot of fun with them on this platform. And you can give it a go right now. And that is it, Mary. Back to you.
Thanks, Kaylee.
Kaylee, I hate to interrupt and correct you, but next month's webinar is on Tuesday, April 23rd, not April 27, which is a Saturday.
Perfect. Thank you, Judge Peck.
All right, we've got party emojis on that one. Excellent, excellent. Well, thanks, Judge Peck. So moving into our introductions for our listeners, Doug Austin is the founder and editor of EDRM Trusted Partner eDiscovery Today. He's an established eDiscovery thought leader with over 30 years experience providing eDiscovery best practices, legal technology consulting, and technical project management services to numerous governmental and commercial clients. And Doug has published a daily blog since 2010 and has earned J.D. Super Awards 3 times. We also have Tom O'Connor, the director of the Gulf Coast Legal Technology Center. Tom O, as he is affectionately called, is a nationally known consultant, speaker, and writer in the area of computerized litigation support systems. Tom's consulting experience is primarily in complex litigation matters where he has worked with firms of all sizes, most recently with the plaintiffs in the BP litigation. He's also been appointed as a technical consultant by various federal and state courts on cases dealing with large amounts of electronic evidence. His most recent edition of his popular book, spicy book, as Kaylee called it, eDiscovery for the Rest of Us, was launched at Legal Week with EDRM's trusted partner, NextPoint, in this edition. And we also have the Honorable Judge Andrew Peck, who you heard earlier. He is a Chambers-ranked senior counsel at DLA Piper, where he advises on copyright and trademark matters. And he also serves as a resource for the firm and its clients on litigation strategy and e-discovery issues from a judge's perspective. Judge Peck retired as a United States Magistrate Judge in the Southern District of New York after 23 years. Writing many of our first eDiscovery opinions, and then later on as the field developed, he wrote on boilerplate objections, 502D orders, and technology-assisted review. Two of the three I think we'll be covering today. And EDRM is very grateful to all three gentlemen for their service on our EDRM Global Advisory Council. And Doug, do we have some cases this month?
Indeed we do, Mary. Thanks, Mary, and welcome everybody to our March 2024 case law webinar on the EDRM network. We do indeed have another 6 cases to discuss this month, addressing topics including in-camera review of privilege logs, waiver of privilege over failing to produce a privilege log, terminating sanctions for deletion, as I go to the agenda slide there, for deletion of text messages, waiver of objections over boilerplate objections, production of private social media messages, and a Rule 502D order to protect against waiver of privilege. One of our panelists is very excited about that last topic. As a reminder, we do welcome questions, and we'll try to get to as many as we can, and we'll send a copy of the slides out after the presentation, so look for that too. Of course, any ideas expressed by us here today are our own, not those of our organizations, clients, or partners. Unlike boilerplate objections, boilerplate disclaimers are a good thing. Before we get started with these cases, here's a quick note. Sorry, but it's true. Here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling, where you can check out the full ruling itself. These case law rulings are available courtesy of Kelly Twigger's eDiscovery Assistant site, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. eDiscovery Assistant has over 35,400 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. eDiscovery Assistant is the definitive source for eDiscovery case law out there. So with that said, let's get into the cases. Our first case is the third ruling we've covered in the in re diisocyanates antitrust litigation, an MDL which involves allegations that the defendants conspired to reduce supply and increase prices for the 2 products you see there. You didn't expect me to pronounce it twice, did you? In this dispute, plaintiffs contended that defendant Covestro's log deficiently provided vague and conclusory descriptions of 818 separate documents that prevented plaintiffs from evaluating the privilege claims in the 4 categories you see there on the slide. Defendants countered that plaintiffs failed to demonstrate that any of the 18 unique privilege assertions were improper because plaintiffs never identified with particularity what their objections are to any specific log entries, and instead asserted categorical challenges and thus failed to make serious efforts to resolve or narrow the challenges pursuant to the ESI protocol. Pennsylvania District Judge Scott Hardy stated, "The attorney-client privilege serves laudable purposes and thus is worthy of maximum legal protection, but nonetheless obstructs the truth-finding process and is to be construed narrowly." Continuing, Judge Hardy said, "The court undertook an independent review of Covestro's log and reviewed the parties' conferral efforts documented in the record and concludes that the necessary assessment of these shifting burdens cannot be completed absent an in-camera inspection of the underlying documents. Given the volume of documents involved and the current procedural posture of the case, it is the court's judgment that appointing a special master pursuant to Federal Rule of Civil Procedure 53 to conduct an in-camera inspection of the documents referenced in the log would be the most just, speedy, inexpensive, and effective means for resolving this dispute. So, Tom, it seems as though we see disputes regarding the level of detail in privilege logs regularly. What can be done, if anything, to establish an expectation of the level of detail that both sides can be happy with?
Well, happy is an awful high barrier there. Happiness between the contending parties may be aspirational. But there's a couple things you can do. I mean, part of the problem, of course, is that the rule itself, FRCP 26b5, is if not vague, sort of general. It's basically says describe the nature of the documents, et cetera, in a manner that without revealing the privilege will enable the other parties to assess the claim. And the advisory committee notes to the 93 amendments point out that they are general and don't attempt to define for each case what information must be provided. Sedona has a commentary on the privilege law. I don't know, Judge Peck, you might know the answer to this. Is it still in the public comment phase? It was in February.
It's in public comment mode, but it's on the Sedona website and can be read by everybody now.
Yes.
And I don't think that when it goes from public comment to final, there's going to be much change at this point.
Right. So I certainly would tell people to take a look at that. A couple of points of interest is it talks about metadata and offers some guidance on metadata in a privilege log and points out, as several of the decisions do, that, quote, the onus is on the responding party to satisfy the requirements of the rule, not on the requesting party to justify why those requirements should be met. But in response to that sort of generalness, a number of districts have come up with their own local rule on privilege logs. I'm particularly fond of the Northern District of Illinois, which talks about it and then says, there will be a privilege log and it should be detailed enough to enable the parties to assess the privilege and should include, and then it lists 6 specific criterion: name of the people, date of the document, type of document, Bates numbers, nature of the privilege asserted, description of the subject matter in sufficient detail to determine if legal advice was sought or revealed. And it refers to a case from their district, RBS Citizens versus Hussein, which was a 2013 case. It also states that in the court in the Northern District of Illinois, the meet and confer requirements of local rule 37.2 apply to privilege disputes. So try to meet those criterion, but if there's going to be a dispute, that court will require you to have a specific meet and confer about the privilege log before you come to the court. So if the court you're in doesn't have a specific rule, I think this one is a good framework to use to, if not make each other happy, it's at least certainly give the court some well-founded analysis of what to do.
Great. Thanks, Tom. That was a lot of great resources and information. And hey, if you can't make the other side happy, making the court happy is probably the next best thing.
Maybe a better thing, actually.
Yeah, exactly.
Probably even more important than making the other side happy.
I would definitely say more important. So, so Judge Peck, are you surprised that the court ordered an in-camera review by a special master instead of deciding to sample the log and review it himself? Do you think he would have done so if this wasn't a large MDL litigation?
I think my answer is yes and no. Look, judges only have so much time in the day and usually a very large civil and criminal docket. And you need to be able to get out of court early enough to go to the golf course. Oh, no, sorry, I didn't say that.
Well, in Judge Faciola's case, to go to the Bruce Springsteen concert.
Yeah, exactly. But seriously, with a large MDL, I think the court was of the view that both parties could afford to pay for a special master. And as somebody who now has a special master practice, I'm all for judges sending things to the special master. But, and 818 documents, to those of us who do eDiscovery every day, it's not very much. To a judge who doesn't have access to review software, that's a lot of documents. On the other hand, the categories, are such that I think the judge could have knocked off a significant number of the challenged documents. I mean, the categories were those that appear to be business documents, those with no lawyer apparent on the alleged privileged document, not prepared in anticipation of litigation. That might be harder to figure out. Then the fourth category was disclosure to third parties, to people who would break the privilege. I mean, what I did when I was on the court was say, okay, give me 10 documents from each of the categories in dispute, or give me 20 documents in total. I'll look at that, give you my ruling, and then you can apply that to the rest of the documents. Judges more and more, reading the cases that you cover, Doug, the cases from eDiscovery Assistant, more and more courts are declining the invitation from the parties for in-camera review. And is that a good or a bad thing? Hard to say.
Fair enough. So Mary, what recommendations do you have for our audience on how to submit a privilege log that's detailed enough to be acceptable by opposing counsel and the court?
Well, one of the first things is just as we would send over a sample production, just to make sure it could be loaded, you can send over a sample privilege log. And so you can flag issues early in the meet and confer phase. So that's one way. And then I'd add to Tom and Judge Peck's recommendation to read the Sedona public comment version of their certification log. And then also EDRM has a past project that has published on privilege logs that has some sample logs more in the categorical style. And these projects are worked on by both sides of the V. So you might have some ability to use them to at least knock down the issues. Like, you're not going to argue over each and every point, but get it down to just the things that matter. And then Mike Berman wrote on both the privilege log project from EDRM and Sedona's certification log, comparing and contrasting, and that might be a good resource. And that was on our EDRM blog on March 3rd.
Great.
Oh, yeah, that's right. Great point. Thanks, Mary. Some really great resources to check out. So we'll move on to our next case, which also has a privilege law component. And it involves an individual plaintiff suing a law firm, and one of them had multiple discovery violations, but not the one you might think. Here, the plaintiff claims she wasn't paid for overtime hours and was fired when she asked for overtime, versus the defendant's contention that the plaintiff was an exempt employee. During the discovery period, plaintiff filed a series of letter applications to compel discovery, complaining repeatedly that defendants were dragging their feet and that their responses to plaintiff's document requests and interrogatories were insufficient in various ways. In response, defendants assured the court repeatedly that they were working on the outstanding discovery items and would comply with plaintiff's demands as soon as they were able to gather the requested materials. Eventually, the court ordered defendants to produce all outstanding discovery no later than April 13, 2023, or face possible sanctions. After defendants made a supplemental production, plaintiff filed a motion for a default judgment sanction, asserting that defendants never turned over certain audio files exchanged between the plaintiff Coker and Goldberg via WhatsApp, and information which could have a bearing on defendants' good faith defense, including other WhatsApp messages. while rejecting plaintiff's pursuit of sanctions under Rule 11 because plaintiff failed to comply with Rule 11C2's safe harbor provision. New York Magistrate Judge Barbara Moses instead construed her motion as made under Rule 37B2 for failing to obey a discovery order. She also found that privilege was waived on WhatsApp audio files, stating, defendants admit in their opposition letter that they withheld portions of the WhatsApp communications between plaintiff and Goldberg, namely certain audio files, because they are protected by attorney-client privilege, but they never supported their privilege claim with a log as required, and they do not argue that they were somehow unable to do so. So she found that privilege was waived on the remaining WhatsApp audio files. Regarding the other WhatsApp files, Judge Moses stated, the possibility that defendants have withheld discoverable documents is not a sufficient foundation for the dispositive sanctions that plaintiff requests. However, given that good faith is an affirmative defense, as to which defendants bear the burden of proof, a preclusion order would be appropriate so as to prevent defendants from benefiting from any failure to produce relevant evidence timely and to protect plaintiff from unfair surprise. Consequently, defendants will be precluded from using that information to supply evidence at trial. So Judge Peck, as I mentioned, the plaintiff pursued sanctions under Rule 11, but Judge Moses rejected the sanctions request under that rule and instead construed her motion as made under Rule 37E2, even though the plaintiff didn't cite that rule. Would you have done that? And shouldn't parties have to cite the correct applicable rule in order for their sanctions motions to be considered?
I mean, it's certainly helpful to cite the appropriate rule, to cite cases that didn't come from ChatGPT, but actually are in Westlaw or Lexis, or real cases that are on point. But, you know, Rule 1, just, speedy, and inexpensive, and that first word, just, means the court should be doing justice. So it is not unusual to say the party chose the wrong rule, let's apply the right rule. You know, sometimes asking the parties to address that so everybody has notice, sometimes just applying it. But, you know, you don't want to rely on mercy from the court, because some days that same judge might say, you cited Rule 11, you didn't do the safe harbor, and oh yes, even more important, Rule 11 does not apply to discovery disputes. Too bad, you lose, make another application later or whatever. And finally, of course, and I don't think I've cited this in a month or two, this was probably, on the defendant's part, a Rule 1.1 violation. That is the unwritten rule that says don't piss off the court. And clearly the defendant, a law firm to boot, you know, not complying with discovery after various orders, not a good position for them to be in.
Yeah, I'm not sure I can remember one where you haven't cited Rule 1.1 at this point, but certainly good to always have it in there again, because it's probably right there at the top of most important rules. So certainly, Mary, waiver of privilege seems like an extreme sanction for failing to produce a privilege log. Do you think Judge Moses could have issued a lesser sanction that might have been more appropriate?
Well, certainly he could have issued a lesser sanction because he's got discretion. But I was struck that reading, they never supported their privilege claim with a log as required, and they do not argue they were somehow unable to do so. Neither does Goldberg's cursory after-the-fact affidavit contain the information that the rules require to support a claim of privilege. So that it's basically they're claiming privilege without doing the work. And so, I don't know, I thought it turned out okay.
Yeah, well, it certainly seemed, certainly considering Rule 1.1 and throwing that into there, it seems appropriate. So, you know, of course, Tom, you would think it would be the individual plaintiff who would have had so many struggles with discovery, but it was the defendant, which was a law firm. Should law firm parties be judged more harshly for discovery violations than non-law firm parties?
Well, yeah, of course, you know, firms, of course, have a whole series of ethical obligations to meet in addition to the the rules. But in this case, I think the fact that it was a privilege log discussion kind of upped the ante. I thought the key was what Mary said about it, the judge's reference to a cursory affidavit. You know, the judge made reference to good faith. I think you had it in that last paragraph on the slide there. Good faith is an affirmative defense, and so he clearly, in several ways here, the judge was bringing Rule 1.1 to bear, and I think that's where the problems lay.
Sure. So, by the way, Judge Peck, Sheila Grilla is asking, can I use your Rule 1.1 during my motions class next week and reference you?
You can, you should, but make sure, you know, that your class doesn't go home and start pouring through the FRCP and saying, where the hell is that? It's the unwritten rule of justice.
There you go. All right, fair enough. All right, we'll move on to our next case, which involves claims of Title VII violations and common law tort claims by a former waitress at a bar owned by the defendants, where defendant Riot obtained text messages exchanged between plaintiff Jones, her friends, and coworkers, and identified instances where Jones appeared to have abruptly stopped communicating with people she'd been messaging almost daily. In response to a subpoena, Jones' own third-party imaging vendor produced a spreadsheet showing that messages between Jones and her coworkers had been deleted from Jones' mobile phone. After Jones failed to comply with the district court's order to produce those messages, the court ordered the parties to jointly retain a third-party forensic search specialist to review the phones of Jones and 3 prospective witnesses. The district court ordered Jones to deliver her phone to the agreed-upon forensic specialist, who was to extract messages containing stipulated search terms and send them to Jones's counsel, Philip Nathanson, who would then send all discoverable messages to Riot and produce a privilege log of those not produced. Jones and 2 of the witnesses ultimately delivered phones to Kuchta, but Jones and 1 of the witnesses obtained new phones shortly after they were ordered to hand over their devices for imaging and didn't produce the earlier phones. It gets better. Kuchta extracted messages and sent them to Nathanson, but the lawyer failed to forward any to Riot despite multiple district court orders that he do so and several deadline extensions. The district court then ordered Kuchta to send all non-privileged messages directly to Riot and later assessed over $69,000 in fees and costs against Jones and Nathanson. After finally receiving the text messages, Riot moved for terminating sanctions for deletion of text messages under Rule 37E2, supported by Kuchta, who concluded that an orchestrated effort to delete and/or hide evidence subject to the court's order has occurred. The sanctions were granted, leading to the appeal by both Jones and Nathanson. The Ninth Circuit Court of Appeals stated, the Anheuser-Busch test, which the district court used in its ruling, generally controls the imposition of terminating sanctions, but we deal here with Rule 37E2. There was ample circumstantial evidence that Jones intentionally destroyed a significant number of text messages and collaborated with others to do so, and that a screenshot of a message sent by a witness to Jones, but missing from Jones's phone in its original form, shows that plaintiff deleted at least one message that had a direct bearing on her case. The court also rejected Jones's argument regarding prejudice, stating the advisory committee notes explain that a finding of prejudice was not included as a requirement because the finding of intent required by Rule 37E2 can support not only an inference that the lost information was unfavorable to the party that intentionally destroyed it, but also an inference that the opposing party was prejudiced by the loss of information that would have favored its position. So it, of course, upheld the sanctions. So, Mary, do you think the Ninth Circuit set aside the Anheuser-Busch 5-factor test applied by the district court in favor of Rule 37E2 because it was a 1995 case? What do you make of the district court decisions to base its ruling on such an old case?
Well, it occurred to me that this is about behavior that happened in 2015. That case arose in 2017, and if we go back to that time period after the federal rules turned on a dime, if you will, for Rule 37E. There wasn't a lot of precedent directly on point. So I think it. I think this is just, you know, them working with our current framework and going to the 37E. People thought there would be no terminating sanctions ever again, no harsh sanctions ever again, and let's just say the courts have found a way.
Yes, well, certainly, if any case seems to justify justify it, this one does. So,
I'm going to just, Doug, I'm going to just jump in for a minute. Mary may have been too nice to the district court, and I don't pull my punches here. This seems to be, you know, something we are seeing much too often, whether it can be blamed on the law clerks who just got out of law school and don't know the federal rules and eDiscovery as they should, or whether it's the judge's fault. But citing to any decision pre-December 2015 in an eDiscovery matter is probably a mistake. You know, you got to look at the 2015 rules amendments and what they say, and the advisory committee notes, and older case law has to be used with caution.
Okay, yeah, that's very interesting, and certainly I thought that was kind of odd to go back to such an old case. So thanks for that additional information, Judge Peck. So Tom, do you think that the fact that Jones and one of the witnesses obtained new phones shortly after they were ordered to hand over their devices for imaging was the deciding factor for terminating sanctions, or do you think they would have received them anyway?
Well, I'm not sure it was the deciding factor. I was struck by KJ Kukta, the forensics expert, saying that, quote, there was an orchestrated effort to delete and or hide evidence subject to the court's order has occurred, end quote. And the court itself made reference to ample circumstantial evidence that there was intentional destroying of a significant number of text messages and collaboration with others to do so. I think the new phones may have been the final nail in the coffin here, but the lid on that coffin had been pretty well nailed down before that occurred.
I like the analogy. So Judge Peck, what do you think? What do you make of Nathanson's conduct in this case in refusing to send the messages to the defendant even after several court orders? Does this conduct rise to the level of action beyond this case, perhaps to a disciplinary action from an ethics perspective?
I would say yes. Now, whether Nathanson could defend an ethics charge on the ground that, well, I wanted to do what the court ordered, but my client insisted I not, you know, that's about the point where a lawyer should move to withdraw from the case. So, yeah, I think Nathanson has got problems. Perhaps that is why the monetary sanction was jointly against Jones and Nathanson, because, you know, query whether it would have been collectible just from Jones.
Yeah, certainly a fair point. So, obviously, you know, while Mary mentioned the fact that, you know, a lot of people say we don't have cases with terminating sanctions, we still do. And when the conduct is egregious enough, and this is certainly one example of that. So we'll move on to our next case, which is a case that was suggested by Judge Peck. And in it, 26 plaintiffs filed an amended complaint in this action, and most of the claims were ultimately dismissed. The defendants served interrogatories and requests for production on the plaintiffs in May 2023. The plaintiffs requested and were granted an extension to respond. However, they only provided general objections without any specific responses or objections to the individual discovery requests. Additional delays followed, and the plaintiffs responded that they were working on the responses and stated that they would serve the plaintiffs' respective discovery responses on a rolling basis, most likely starting the week of July 3. Plaintiffs also proposed a meet and confer for July 5 or 6. Defendants replied 90 minutes later, indicating their availability to meet and confer on July 5 and 6, but plaintiffs didn't respond. The defendants sought an order for the plaintiffs to pay their attorney's fees and expenses and argued that the plaintiffs had waived all objections to discovery. In considering the parties' arguments, Delaware Vice Chancellor Paul Fioravanti stated, when the end of that extension came to pass on June 20, 2023, plaintiffs collectively served a single response consisting of 7 pages of general objections, but nothing else. The general objections consist of boilerplate and, in many instances, duplicative objections that are untethered to any specific request or interrogatory. Inexplicably, plaintiffs did not provide a specific or substantive response to a single interrogatory or request for production. Plaintiffs do not defend their general objections as being compliant with the Court of Chancery rules. Instead, they argue that waiver is too strong a sanction for the circumstance. The Vice Chancellor also rejected the plaintiff's citation of Twitter v. Musk, stating, unlike the defendants in Twitter, the plaintiffs did not walk back any of their boilerplate general objections. Indeed, even the few plaintiffs that later filed actual responses to the discovery repeated the same general objections verbatim and incorporated them into every specific interrogatory response and response to the request for production. As a result, the Vice Chancellor found that all objections were waived, except those on ground of privilege and work product, and stated, even today, almost 6 months after the deadline, many of the plaintiffs have not offered a substantive response to a single interrogatory or document request. Plaintiffs' conduct was not substantially justified, and there are no other circumstances that made an award of expenses unjust. Accordingly, the defendants are entitled to the reasonable fees and expenses under Rule 37. So, Tom, do you agree with the plaintiffs that waiver of objections is too strong a sanction for their actions?
Well, not in this case. I think if there's a poster child case for Judge Peck's Rule 1.1, this seems to be it. First of all, they filed boilerplate objections, which have been a subject going back ages. Right. I mean, that not doing that is certainly something that they should have been aware of. And then when they were told to file second responses, not only did they file boilerplate, but apparently they just filed the same objection. They filed the same responses with the same boilerplate. And then, as the judge pointed out, 6 months later, after the deadline, they still hadn't offered any substantive responses. So, I don't know how else he could have more strongly worded it. Plaintiff's conduct was not substantially justified. So, no, I agree with this totally.
Sure. Well, maybe this is Rule 1.1a. Don't piss off the Vice Chancellor. But still notable there. So, Judge Peck, you said in your ruling in Fisher v. Forrest a few years ago that, quote, from now on, any discovery response that does not comply with Rule 34's requirement to state objections with specificity will be deemed a waiver of all objections except as to privilege. So are there any objections to that which you would consider, like Chancellor McCormick did in Twitter v. Musk?
One can certainly extend what I did in Fisher versus Forrest to Twitter to privilege. There are many cases. Fisher against Forrest was in February 2017, a year plus after the 2015 amendments to Rule 34 and the other 2015 amendments. And I was frankly fed up at that point with lawyers using boilerplate. I continue, obviously, to follow the case law. And it's amazing to me how many lawyers are still using boilerplate type objections in their responses to discovery requests. And really, all you have to do to turn a boilerplate objection into one that is possibly sufficient is to add the word why or because. This request is overbroad because it seeks information going back to 2000, and the contract at issue in this lawsuit wasn't entered into until 2010. Just things like that as to why there is a basis for the objection, and not just copying all the objections from a form file and hoping that there is something there. So yeah, I could see it applying to privilege as well, if it's a sufficient violation of Rule 1.1 in particular.
Sure. So, Mary, it seems, we certainly saw in this case, and it seems like we see a lot of cases where one party's counsel just isn't responsive to communications from opposing counsel as they should be. So what can parties in litigation do, if anything, to make sure their representation is on the ball in the discovery process and cooperating with, in communications?
Well, I think it's important to know if you're in a rocket docket or if you're with a judge who likes to move things along, and certainly understanding the opponent's communication rhythm. In the opinion, they mentioned 90 minutes was one of the responses. And certainly you shouldn't let communications go unanswered. There should be a central person who is either copied or forwarded all messages, so that it's clear which messages need a response and something doesn't go unanswered and then you get in trouble because of it. And that begs the question of, can you, create from whole cloth everything that you need in the moment? You probably should have a playbook with templates for various situations that could be customized. Now that in a case like this where they just want to do regular boilerplate objections and not edit them, I don't know, editing templates might be a little bit too much too, but and then just documenting all of the communication that goes on from the get-go. Everything from, the things that automatically, just by the way they have to be done, are documented, like service of process and whatnot. But also your request to preserve, your RFPs, request for production, and all of the meet and confer back and forth. All of that should be documented.
Yeah, absolutely. And I think a party could certainly just kind of request regular status updates from their counsel. What's going on, understanding what the case schedule is, and understanding, what they're where they stand and so forth is probably kind of another way to kind of light maybe a little fire under the counsel, which in this case it certainly seems like they needed that for sure. Oh, go ahead, Judge Peck.
I was just going to say, for the audience's benefit, Sedona has two primers with respect to discovery requests and discovery responses, with lots of really helpful suggestions on how to avoid boilerplate and comply with the rules.
Okay.
Yeah.
Hey, and Doug, could I just make a note real quick?
Sure.
Somebody's asked a question as to why this opinion was unpublished, which is something that pops up every now and then. It happens a lot in California. I don't know what the standards are in Delaware, and my experience has been that as a general rule, a case is unpublished because the court, the presiding court, decided that or deems that it doesn't have sufficient precedential value. So in some way, perhaps the chancellor here thought it was a one-off and they didn't want to publish it. But I don't know, Judge Peck, any take on that?
Something that is only in Westlaw or Lexis and not designated for the federal reporter system on the federal side is technically an unpublished opinion. It used to be in the older days that in order for judges to get certain opinions even onto Westlaw or LexisNexis, one had to send it into them. It then got to the point, at least in the bigger federal courts, where the services worked something out with the clerk's office or just, watched everything. And we are seeing almost everything, certainly from the Southern District in New York, from the California districts, everything, including some things that judges would probably prefer. We're not ready for prime time. We're seeing everything in federal system going on to Westlaw.
Okay.
Yeah, well, great question from the audience. And just because an opinion is unpublished doesn't have an impact on the value of it. It just aligns to those criteria. By the way, Sheila,
just to be clear, an opinion from a judge in the same court, whether published or not, is not binding. So if I had written a decision and one of my colleagues did not think it correct, they could ignore it or they could go the other way and all of that. Only a decision from the circuit court, or heaven forbid nowadays, the Supreme Court, must be followed. So it's really the persuasiveness of the logic of the opinion and perhaps of the author of the opinion. In the early days of eDiscovery, opinions from Faciola, Grimm, me, Dave Waxy out of Kansas, because of who we were and that we were on the speaking circuit, those tended to be followed even outside of our districts.
Great point. As Sheila Greela notes that paralegals are taught to look at the request from what's wrong with the request, then draft the objection. Sounds like some of the paralegals could teach the lawyers a few best practices on that front. We're starting to run a little short, so we'll move on to our next case, which involves a variety of tort claims against the NCAA, including some of the claims you see there. Related to current and former college baseball players who alleged they were subjected to rampant sexualized harassment and misconduct at the hands of their coaches. At issue were two of defendants' requests for production. One sought social media feeds from Facebook, Instagram, Twitter, Threads, LinkedIn, Snapchat, TikTok, YouTube, or any other social media account maintained by the plaintiff since the alleged abuse commenced for that plaintiff to the present, while the other sought an export of all information for each of those accounts. To each of these requests, plaintiffs responded, plaintiffs incorporate their general objections, objections to definitions, and objections to instructions as if fully set forth herein. Plaintiffs further object to this request as unduly burdensome and disproportionate to the needs of this case. Plaintiffs are willing to meet and confer to narrow the scope of this request. Indiana Magistrate Judge Mark Dinsmore began his analysis by stating, as an initial matter, the court notes its concern with plaintiffs' lackadaisical approach to discovery in this case. Sounds like another Rule 1.1 scenario. Defendants served its discovery request in August 2023, yet as of February 5, 2024, plaintiffs had not yet produced any electronically stored information responsive to defendants' requests. Plaintiffs essentially held all their social media information hostage to defendants' agreement to their review proposal, not making any real effort to begin production of indisputably relevant information because the parties were debating the use of search terms as a way to reduce plaintiffs' burden of culling their social media information. This is not an acceptable way to approach discovery. Ultimately, the only issue left was production of private messages. Judge Dinsmore rejected the plaintiff's proposed solution that they not be required to produce any of their private messages, stating, first, plaintiffs have not satisfied their obligation to demonstrate specifically what the burden would be for them to review the private messages for relevancy. Indeed, when asked at the hearing, plaintiffs were unable to answer the most basic question of how many private messages there are, demonstrating that they've made little to no effort to quantify any burden that may exist. Second, while plaintiffs' desire to maintain the privacy of their irrelevant private messages is understandable, plaintiffs' privacy concerns are largely obviated by the fact that they're proceeding under pseudonyms in this case. So we ordered them to produce the private messages, but also included additional protections such as a protective order and filing private messages under seal. So Judge Peck, if the plaintiffs had been responding to the discovery request, do you think Judge Dinsmore would still ordered them to produce the private messages, and would you have ordered them to do so?
I mean, obviously, a party's conduct in litigation always is going to influence a judge's decision. But here, I think even if they had produced all the other messages from day one, et cetera, they would have been, and I would have ordered, if this were in front of me, producing these so-called private messages. There is no such thing as a private message. If it's, whether it's email, whether it's text, whether it's Slack, whatever it may be, or social media type as here, if it is relevant, it has to be produced. I know one early case analogized to, if a party kept a diary of their most private thoughts about what, was then in litigation, that would have to be produced. And email or private messages of any sort is just like that.
Yeah, that's I remember that. I remember that analogy. Mary, here's yet another case with boilerplate general objections. Why do you think parties respond this way? And do you think it's a lack of understanding of the rules, or do you think it's a lack of knowledge about how to provide specificity to their objections?
Yeah, I would say both. I mean, we still use TIFF. We still have cases with the old 37E. And so the boilerplate objections still have a little bit of time before they're like front, center, everybody's got it, and is going to be compliant. But the other piece is you have to know a little bit about your case and about your data before you can make a good objection. And so early in the case, they might not have that understanding, but they should at least be able to articulate maybe they don't want to produce private messages because of embarrassment or privacy of other individuals, or, they could raise something, even if they can't quantify.
Yeah, fair enough. So Tom, what advice would you give to our audience on how to ensure protection for private and sensitive information in litigation?
Well, first and foremost, don't take an approach, as Judge Dinsmore noted, and you quoted it in the slide. Don't take a lackadaisical approach. Take this seriously and take a detailed, thorough, efficient approach to dealing with this. But in your column on this case, Doug, when it first came out, you quoted Judge Dinsmore also gave 4 specific things that people could do. Designate messages as confidential under a protective order. Any portion of private messages that are used by either party in conjunction with the court filing could be filed under seal. Names and other identifying information of any third party should be redacted for anything that's being filed. And defense counsel should take extra care to ensure that the relevancy of any private message to the claims or defenses in this case before using that message in a deposition or a court filing. So take a little time to be a little more detailed, and take a look at Judge Dinsmore's decision.
And here's a point for the party.
Yeah.
Pick up the damn phone. If
tell us what you really think, Judge. Come on, don't do that.
If you send a message, it's not private. So know that, and think and act accordingly.
Right.
The great Kingfish down here in his day, Huey Long, once was quoted saying, "Never put in writing what you can say on the phone."
There you go. Yes, indeed. It seems like newer generations don't like to talk on the phone, but hey, it is what it is. But that's great advice. All right. So in close to 4 years of doing these case law webinars and promoting them on LinkedIn, we've never had one where the Honorable Judge Andrew J. Peck has chimed in on LinkedIn saying he can't wait to discuss this case. Until now. This is the second ruling we've covered in the Lubrizol v. IBM case, and here Lubrizol alleged that between July 2019 and October 2021, IBM deleted the email boxes of a number of IBM personnel who played key roles on the S/4HANA project that IBM failed to implement a litigation hold until May 2021, after Lubrizol filed its complaint in April and was explicit about its plan to sue IBM as early as April 2020. Lubrizol also alleged that even after IBM implemented a litigation hold, IBM applied it to only a handful of project consultants. IBM submitted a Rule 502D order request, which would authorize IBM to produce, without waiving the attorney-client privilege or attorney work product protection, all documents and communications concerning the preparation, implementation, institution, application, and dissemination by IBM of document preservation and litigation holds through May 15, 2021, responses to Lubrizol's interrogatories on the same subject, and a Rule 36 witness on the same subject. Lubrizol objected, arguing that Judge Armstrong lacked authority to enter a Rule 502D order that would permit IBM to intentionally rather than inadvertently disclose privileged information without constituting a subject matter waiver of all other documents and communications on the same topic. Regarding IBM's Rule 502D order request, Ohio Magistrate Judge Jennifer Armstrong stated, as an initial matter, I agree with Lubrizol that it's unclear whether a court has the authority to enter a Rule 502D order that covers intentional rather than inadvertent disclosures of privileged documents and information. The Sedona Conference has taken the position that a court may do so, opining that a Rule 502D order may address not only inadvertent waiver, but also instances in which intentional disclosure will not result in waiver. A number of courts, however, have reached the opposite conclusion, holding that Rule 502D does not extend to intentional disclosures. I therefore conclude that the scope of IBM's proposed Rule 502D does not eliminate the risk of selective disclosure, and that it is not likely to meaningfully narrow the disputes between the parties. And as IBM correctly notes, nothing in the text of Rule 502D appears to give me the authority to unilaterally impose on IBM a broader waiver of the privilege than IBM itself has agreed to. So she denied the request for a Rule 502D order. As a result, after applying the three-factor Hearn test regarding waiver of privilege and finding all three factors were met, Judge Armstrong found that IBM has waived privilege with respect to IBM's document preservation efforts, whether IBM reasonably anticipated litigation at the time of the alleged spoliation, and when IBM identified the disputed custodians as individuals who might possess information relevant to the case. So, Mary, we don't see requests for 502D orders rejected very often. What could IBM have done, if anything, to enable their 502D order request to be granted?
Well, Doug, Judge Jennifer Dowdle Armstrong said, I therefore conclude that the scope of IBM's proposed Rule 502D does not eliminate the risk of selective disclosure, and that it's not likely to meaningfully narrow the disputes between the parties. So I think getting your 502D order at the beginning, when both parties are sort of on an even playing field, not when it's needed for one party, and not when it looks like a selective cherry picking exercise.
Yeah, that's certainly a great point. So, Tom, IBM certainly is no stranger to litigation and should have established policies in place for preservation. So how should an organization like IBM ensure that established policies that they presumably have are followed correctly?
Well, there's an old saying in IT circles, a question that's asked all the time when you're dealing with a problem: who owns this? Who owns this project? And I think that's the problem. You've got to have somebody, a person who's in charge of the litigation hold policy enforcement. And then it can't just be a one-time thing. You know, we've talked about this a number of times. You can't just send an email around to everybody saying, don't delete this stuff. You got to have a follow-up. You got to monitor it. Somebody's got to be on top of that all the time. It's harder and harder the bigger the company is. The most problems I've ever had with implementing litigation holds have always been with larger corporate clients. The larger the company, the less centralized control there seems to be. Seems counterintuitive, but there it is. And then finally, talk to your outside counsel, who probably has a lot of expertise in this, and ask what you should be doing. Are we doing this right? What can we do? How can we improve this? Don't keep it all to yourself.
Yep, absolutely. So, Judge Peck, what do you make of Judge Armstrong's statement that it was unclear whether a court has the authority to enter a Rule 502D order that covers intentional rather than inadvertent disclosures of privileged documents and information? Do you agree with that statement, and do you agree with her decision to deny the request for a 502D order?
no and no. You know, 502D is mostly used now so that you don't have a fight under the 502B as in boy of did you take careful enough steps to review for privilege? Did you act promptly enough to claw back a privileged document that slipped out, etc.? But let's go back to the advisory committee notes. And in this case, the advisory committee notes were Congress's notes. And one of the purposes of 502D, although not used for this very much, is to allow for quick peeks and clawback agreements. It's, you know, what we used to do pre-502D, pre-eDiscovery in the paper days. Okay, there are 50 boxes that may contain relevant documents. We don't want to go through it. We're going to put them in a conference room, hand you some Post-it notes for the other side and say, go through it, mark what you want. We're not waiving privilege. Once you've marked what you want us to copy for you, we'll then review it for privileged. It's not done very often nowadays, but the rule is broad enough to cover that. Secondly, the Sedona-approved version of a standard 502D order, which frankly was my 502D order, says the production of a privileged email, whether inadvertently or otherwise, is not a waiver. So yes, it can apply to intentional disclosure. Now, the other thing that the court here ignored, and I don't know if the parties called it to her attention or not, this would be a 502A situation on top of 502D. 502A says when it's an intentional disclosure that a waiver applies to undisclosed information if the waiver is intentional. Secondly, the disclosed and undisclosed information concern the same subject matter. And three, that they ought in fairness to be considered together. The FRE 106, I believe it is, rule of completeness. So a 502D order here, applying with respect to the subject matter of what was done to preserve, et cetera, if not, you know, oops, a privileged email slipped out, but we intentionally are producing the material that shows we are good, well, that triggers 502A, and without anything further other than application of the rules, IBM would be required to produce everything else on that subject matter because of that fairness principle. So I think counsel may have dropped the ball in not bringing that to the court's attention. I could understand why a court would be nervous in this situation, but I clearly believe the court had the authority to enter the order and that the protection would be applied automatically through use of 502A on top of the 502D order.
Very interesting. I hadn't thought about 502A, but
Yeah.
Good information. And I'm shocked that you disagreed with the denial of the 502D. Just kidding. But yes, I was definitely very interested to hear what you have to say about this case. And,
as I've often said, counsel should get a 502D order from the court in absolutely every case in federal court and in as many state court cases that have their equivalent, or even if they don't have the equivalent, at least would give you cover in that particular case.
Yeah.
Don't leave home, like the old American Express commercials used to say, don't leave home without it. Get your 502D order. And as Mary said, get it early in the case before there's a reason for the parties to think differently about its applicability.
Yeah, good point. Because had IBM done it early, maybe it wouldn't have come to this. So certainly well put. So there's the contacts page, and our next case law webinar, as Judge Peck pointed out, is Tuesday, April 23rd. And there's a cake with 4 candles on it, which doesn't have to do with the webinars. It has to do with something else. And by the way, it took me 5 tries to generate on DALL-E because DALL-E can't seem to count to 4. Kept giving me more candles than 4 on my images, even though I said 4 candles, come on. Anyway, tune in next time to find out what the 4 candles is for. And in the meantime, with that, I will say thanks to Mary, Tom, and Judge Peck for their terrific insights as always. And I'll turn it back over to you to close us out, Mary.
Thanks, Doug. And we thank you, of course, for anchoring, and the great Tom O'Connor and the Honorable Judge Peck for this wonderful presentation. And our thanks to the EDRM community for your kind attention. And if you really, really liked it, show Judge Peck, Tom O, and Doug some love with the emojis at the bottom of your console. And we'll see you next time on the EDRM Global Webinar channel. Thank you.
Thanks, everybody.
Thanks, folks.
Bye all.